So without further ado, it is my distinct pleasure and honor to introduce you to one of my great friends, Alexis Swansea. She will be talking about the amazing world of business law tips, copyright, and IP for your business. So hopefully this will answer some questions. But a little bit about Alexis. After graduating from Texas A&M University in 3 years, Alexis attended SMU Dedman School of Law, where she was on the International Law Review and honed her advocacy skills in intramural and interscholastic competitions. As a part of the Dedman School of Law Criminal Justice Clinic, Alexis served as the first chair attorney in jury trials on behalf of her client. During law school, she satisfied her intellectual curiosity by studying human rights across Germany, as well as international environmental law and the English legal system at Oxford University in the United Kingdom. Prior to joining Kessler Collins PC, Alexis gained practical experience through an internship with the Federal Trade Commission and an externship with the U.S. Bankruptcy Court for the Eastern District of Texas and the legal department of a real estate developer. Alexis aims to create long-lasting relationships and will aid in providing personalized advice and solutions for her clients' needs and goals. Currently, Alexis specializes in commercial litigation, including copyright and intellectual property and real estate. I cannot think of a better person to send over to this lovely topic. So Alexis, it's all yours.
Thank you so much, Callie. I only had to pay her about $100 to say all those nice things, so I appreciate it. Before I begin, I just kind of want, again, my name's Alexis Swansea. Very excited to be here, and I'll be covering intellectual property and some general business tips. Candace did a wonderful presentation and mentioned some things that might also be in this presentation, so I apologize to if I seem repetitive or anything with that. And I also want to kind of give a caveat because I know a lot of attorneys are presenting today and they're all saying, hire an attorney. And you're like, well, you're an attorney saying hiring an attorney. When we say that, we think it's a lot easier to, you're investing in your business, you're investing in your brand on the front end. So it's almost like electricians, doctors, you can Google, you can find YouTube videos, and in a lot of ways things will work out if you do it yourself. And that is a route to take. And sometimes that, nothing bad happens and everything turns out great. However, with some things, maybe an electrician would be better equipped to do the job. Maybe the doctor would be a better equipped to do the job. So when we say hire an attorney, we mean that as in we think it will be best practices. So that's kind of the thing. In this presentation, I am taking that to mean that we're trying to give you the tools where, it's an introduction into the topic or the summary of what we are talking about. So whenever you're going to either hire an attorney or do it yourself, you kind of have those first steps and you're kind of understanding what you're going to need. You kind of know what it will consist of, so that, when you enter into these conversations and things, you are understanding how to get your business from point A to B. You just might need a little help doing that is kind of what we do. So as I'm sure you are all aware, for those of you who are starting your own business or looking to start your own business, roughly 20% of small businesses fail within the first year, and 50% fail within the first 5 years. And that's from the U.S. Bureau of Labor Statistics. Now, for those of you who are still tuned in after that comment, you're probably thinking, I could probably have that same advice given to me in a few weeks at Thanksgiving by Uncle Joe, or I'm sure she is the best person to talk to at parties. I am definitely not the best person to talk to at parties, but that's mostly because I steal all the desserts. But contrary to my optimistic lead-in, I am a strong believer that education is power, and I'm passionate about small businesses. That is why I think it's important to understand not only statistics that might not be the most encouraging, but to understand the why and how you can avoid it when setting up your business or starting those first couple of steps. Unfortunately, as a small business, you're the underdog, and it will be an uphill battle. But I think that, coming here and taking steps like these today, you're going to work to make sure you're not part of that 20% or that 50% in 5 years, which I think is very important. and that, using your knowledge, you can avoid a lot of pitfalls I think that other companies might fall into just because you don't know what you don't know. And that's the whole thing. Like I said previously, this presentation is designed to give small business owners or soon to be small business owners a survey of intellectual property and general tips. Unfortunately, I do not have the time, and I sincerely doubt you will want to hear me drone on for hours and hours about these topics, but so you will not learn everything you need to know about intellectual property, but I hope you'll be able to pinpoint the path that you want to take and understand the first couple of steps of what you will need to do with these. So as an overview, we're going to kind of have a nice understanding, 30,000 foot view of the different intellectual property rights that your business can acquire. And then we're going to dive a little bit deeper into each one of them. And then we're going to end with some best practices and things that we can do. So first off, there are different types of intellectual property rights, and each one protects a different aspect of your business. First of all, your trademark is your brand. Different speakers today will be talking about specifically about branding and marketing, but this is kind of your legal protection to protect that brand that you are trying so hard to build and pump up. For example, if you're starting your own lawn business, a trademark is the logo that you put on your uniform or your business cards or any other marketing materials. And the thing is, it's such a strong statement because when I say double arches, you're automatically thinking of a certain gold, red, probably McDonald's, those sorts of things. And that is really, when I say brand, what I'm meaning is that instant recall of, okay, McDouble, those sorts of things. I instantly know that is from McDonald's. So going on to the next intellectual property right is a patent. And that's your invention. So if you develop a new type of lawnmower that runs on oranges, I'm not saying that would work, but just a different process or something that's new and inventive, that those plans and processes could be protected by a patent. And that's a different type from the trademark. And then a copyright protects your artistic or literary work. So for the lawn business, that would be your marketing. For example, if you come up with a commercial and make this catchy jingle that really promotes your business, you could copyright that. It's, for example, the Chili's, while they have their trademark with the Chili's logo, that's their trademark. I don't know if they have any patents, but their copyright could be the commercial that was aired for, I don't know how long ago, but it's like the Chili's baby back ribs, and that is why I'm a lawyer, not a singer. And moving on with domain names, that is the web address that identifies your website. Those are registered through a domain name registrar. Sometimes it's confusing that domain name is their trademark name, like booking.com. So that's booking.com is the trademark, but it's also what you put into your web address to search on booking.com or something equivalent. This is where some of the rights come together. If you register a domain name with a domain name registrar, that includes the trademark of another party. Like if they were registering booking.com, but a different company owned booking.com under a trademark, then you may have to surrender that domain name. So that's kind of how all of these rights kind of play off together. And that's where your lawn mowing business's website would be. And then your business names is the registered name through the Secretary of State. It's just simply the name that you do the business. Candace went over a lot of the different types of entities and stuff, and that's kind of what you would file with the Secretary of State that she was mentioning. So all of these different intellectual property rights, that's kind of your portfolio, and that's kind of what will add value to your company. So kind of going from that stuff, I'm kind of starting from the bottom of the list, but the business names. So these business names can be registered by the Texas Secretary of State's website. And this is, I have screenshots here, kind of like the process, how you do it, because sometimes it gets a little confusing. So you go to the Texas Secretary of State website, and you go right over here to business services. And they have different information that Candace was also talking about with the first couple, like business basics and business startup information. They have forms, things like that. But if you go down to SOS Direct online searching and filing, you'll come to this page right here. And so then you create a username and a password, and you can go on and you can search whether your business name that you're really wanting to utilize or use is already on the system, or if it's registered in Texas. And so you can do a find entity, you can do a name availability search. So all of this stuff is available at your disposal when you're making those primary steps on choosing your business name. And so I work for Kessler Collins, so I just, if I would want to make a company name that's Kessler Collins, that's what I would enter. It's a nominal price. I believe it's $1 per search, so it's not that much. And so once I search that name, all of these names come up that's remotely related to it. And it's 3 pages. So 29 results come back. Sometimes you have thousands that you're having to look forward to, but this is also, once you're being registered, this is what will be known to the world whenever in the business sense. So if you are, once you file and create that entity, it will be on here. You will be able to view who is the owner of the company, who's the registered agent. Registered agent is the person who will accept documents on your behalf. Unfortunately, if you get sued, those sorts of things, you will be able to know how to do it. And so I pulled up the filing number. I clicked on the filing number for Kessler Collins, and this is what came up. So, and that's the specific name of the corporation. And like I said, registered agents, filing history, certain filings, if you're under a specific type of entity that Candace was talking about, you might have to show certain filings, not tax returns or anything on that, but just your bylaws, things like that, and your management and assumed names. So this is where we're kind of getting anything. I think someone asked Candace a question about a DBA. So what is a DBA? A DBA stands for doing business as. This may also be known as a fictitious business name or trade name, depending on which jurisdiction you are in, like which state or things like that. So why use a DBA? Well, if you're a sole proprietor or a partnership, you may want to do business with that name, with a name that is different than a business name. That gives your business a certain marketing identity that is separate from your personal name, but is not the same as a corporate structure in terms of the law. So if you, like Kessler Collins, PC, professional corporation, that's their corporate structure. But if I was Alexis Swansea, DBA, Kessler Collins, that wouldn't actually be a corporate structure. A DBA is not a corporate structure. It's just another name you would go by, but it would still be a sole proprietorship. So therefore you is not a corporate structure. If you're a corporation or a LLC and you have your formal name, you are, you have that name registered here underneath the name. Okay. But what if, but if you want to use a different business name other than the name of your corporation, you can register a DBA for this purpose. So you have 2 different instances, kind of why you would want to use a DBA instead of the name that's either on file or your name because you don't have a corporate structure set up. But why would you do this if you already have a corporate structure, identity, something else? Well, there might be potential marketing benefits possibly. For example, if you really like Son and Son Co., but you want to form an LLC because that is better for you and there are certain benefits and taxes and things like that, your formal name can be Son and Son LLC, but it doesn't have the ring to it a Son and Son Co. does. But you can market and brand as Son and Son Co. Or Another thing is if you start a Sun and Sun Roofing business, and so your corporate structure name is Sun and Sun Roofing LLC, but you want to start getting into pools or plumbing, you might want to have a DBA where it's connected to the corporate structure without forming a whole entire different entity. So you might be doing Sun and Sun Pools, and that will be your DBA. So that's kind of the point with business names and how you can kind of navigate a DBA with your corporate structure or a DBA with your own personal name. So keep in mind that Texas offers DBAs at the state level. So that means like, under assumed names or associated entities, but not all states offer assumed or fictitious business names at the state level. And some states may require you to register at the state level and at the county level, or just at the county level. So that's one thing to be aware if you're hoping to take this knowledge to another state. Also be aware, because if you want to go from one type of business to the other, you need to make sure the ownership is identical. So if you wanted to go from the roofing business to the plumbing business, you need to make sure that, your DBA structure is kind of this, it's the same as the original ownership structure, because you have your management listed on the Texas Secretary of State. So a DBA also does not allow you to get a separate business bank account for that aspect of your business, or manage the finances for that aspect of your business separately. It's just a name. So what Candace was saying at the end in response to the question was talking about, do I need to make a separate DBA, separate bank account? She was saying, like, go through the Secretary of State, get this EIN number, then go to the bank and set up your bank account. So that's kind of things. Also, if you're setting up a DBA, you have a corporate structure, but you want to use a DBA name. So like Sun and Sun Co. is the DBA name. You might want to trademark it just to make sure that it's protected. So that's best practices. So trademarks, that's where we kind of lead into. A trademark is a word, a name, a symbol, or a device, or any combination of that is used to distinguish the goods of one person from goods manufactured or sold by others, and to indicate the source of those goods. Like I said, the double arches, what do you automatically think of? McDonald's. So you know that if you get something with a box that has the double arches on it, that has the McDonald's, and it looks so similar, you're assuming that that burger or, whatever you get is from McDonald's. So that is the whole purpose of the trademark. And what is a service mark? Well, it's same as a trademark, except they identify and distinguish services rather than products. And this is, the service has to be separate than selling the product. So if I'm selling certain bottles of something, I have to, in order to get a service mark, I have to be doing something separately than just selling those bottles. I have to be providing some sort of service like hair, professional services like legal services, or the lawn mowing service that I mentioned previously in the overview. So that's things, I'll probably be using them interchangeably. That's pretty common in the industry, is just to say, your mark, your trademark. It will also apply to service mark. It's just that little distinguish between goods and services. Other types of marks that you may come across that I haven't listed here, one of them is a certification mark. And that's your product that is registered under your own trademark met certain standards of your source, or yourself, your company met certain standards, or your product met certain standards. It's just a type of trademark, and it's used to show consumers that particular goods or services, or the trademark owners, so the companies, have met certain standards. For example, they might have certification marks for geographic. So potatoes that come from Idaho, they might have a certain mark on the product that you can utilize because your potatoes come from Idaho. Or real Florida oranges. That's another thing. So, and on the other hand, it may certify that the work or the labor on the products or services was performed by a member of a union or other organization that met certain standards. It's just to kind of add another certification on your product and to have consumers buying that product because it met certain standards, like, oh, I really want real potatoes from Idaho, or I want to support a certain union, so I want to do that. And as the years have gone by, people are becoming more health conscious. They're becoming more conscious of the brands that they are buying. And so it has become more and more important with certification marks in the past 10 to 20 years. Collective marks is another sort of thing. It shows particular members of an organization. So this is different than certification marks, where the product just or the business met a certain standard, saying, hey, we're this or that, I've hit that threshold. The collective marks is a certain member of an organization, like the business is a member of a certain organization, and so that's the same mark you can do it. It's, again, just adding confidence into that brand, adding confidence into that product that you have that has a certification. Trade dress, that is a design or packaging of a product that makes the source or design of the product immediately recognizable. For example, Coke bottles, the old glass Coke bottles and stuff. So that's kind of what could be a trade dress. And then you have house marks, are marks used by an entity on a wide range of goods. So like Toyota, they have different cars of the brand and different lines, but Toyota is their house mark. So, and kind of coming back to it, it's like, okay, trademarks can be something that shows I met a certain standard, things, how do I express that trademark? How do I, what falls as a trademark? I mean, it could be words such as the word Nike, sounds. I don't know if anybody uses Yahoo anymore, but they have a certain sound when an email comes in or something, you instantly recognize that it's a Yahoo. Colors can also be shapes, motion, or even a scent. So that's one that might not automatically be thought of when you were thinking about trademark. But yes, you can trademark a scent. So why should we care about trademarks? I've drone on and on about it, but why does it matter? So it drives consumer purchase decisions. It's consumer loyalty. So when you're in a town that you don't know, you see certain, certain fast food restaurants or restaurants, you're not quite sure. You kind of see the double arches. You're like, okay, I know that's a McDonald's. I know what I'm going to get, good or bad. It doesn't necessarily matter, but I know what I'm going to get with McDonald's. And so I trust them to a certain extent to deliver the food that I expect. Same thing with when you go for the brand at the store. Do you go for the real Oreos or do you go with the knockoff Oreos? It's those sorts of things. And that makes sense because if you don't like a certain thing, you'll probably not buy it. But if you really like something, you might try to look for that brand as well. So it kind of goes on both sides. Also, it distinguishes your product from your competitor's product. Because obviously, if you're selling things, if you're selling your product, you might be the first in the business. But if you're very successful, of course, people are going to want to share in the profits and things and try to make up their own product as well. So that's pretty important. And that's exciting to do. But that also wants to make sure, what if that your competitor's product isn't as good as yours, but if they have the exact same trademark, how does your consumer know to distinguish between the two? And you don't want to you want to make it as easy as possible for the consumer to drive those purchase decisions. So that's also another thought that you need to keep in mind as to when you're thinking about whether to invest in a trademark or how much to invest time and effort. That's kind of some of the things. Again, it's one of the biggest investments early on because that will stay with you. You've heard things about rebranding. Certain businesses need to. maybe due to a PR scandal or because, the brand just doesn't work for them anymore. So they're constantly rebranding, but that trademark could stay with you for the length of the business, which is an investment. So this is kind of where I bring up an attorney and coming in with the trademarks, because there is a process. It is intensive and it is lengthy. So before you register, you apply for a trademark, you're trying to look for an attorney. What type of questions should you ask that attorney? And some of that is, what is your experience in specifically trademarks? Do you have any trademarks of your own? Have you worked for the USPTO? US Patent and Trademark Office handles the applications for the trademarks. So if they were, and attorneys examine the applications and they determine whether or not they are going to be registered or not. And so they might have some insight. Also, how much are your fees and how are they calculated? Is it on an hourly fee or is it a flat fee to have the application for the trademark? And how does your firm or yourself, how does your attorney track their deadlines? It's important to know to have a system, because as we go on through this process and I kind of tell you a little bit more about the length of the process, there are certain deadlines that you have to meet to respond to certain things. And you need to make sure that, they might have 50 trademark applications of the thing. You need to make sure that they have a system to track the deadlines. Like, I need to check on this to make sure that we haven't missed any deadlines or anything hasn't come back. So when we are going through trademarks, you're kind of figuring out whether to register, whether with the state or the federal government, or just to have no registration. So if you choose to make a trademark and that's it, that's kind of your stop. In Texas, you can utilize the TM symbol or the SM symbol, trademark symbol, or the service mark symbol to indicate that you have adopted this trademark or service mark. And that's fine. That's whenever you start of hoping that you are the first person to start utilizing that trademark, and definitely have some documentation that you've sold a product or something like that right at the beginning, so that you can get that time in that, you first started using this mark on this and this date. This is the first transaction that had that trademark on your product. Or, using common commerce with service marks, promotional materials. Then if you go up to the state registration, I'm specifically talking about Texas. This puts the rest of Texas on notice that you claim ownership of the mark in Texas. So that's a little bit different than common law. Common law, you would have to kind of show your area, your geographical region. Are you in Dallas? Have you been using the mark in Dallas? Does your market reach on Dallas city limits, or is it all of DFW? Does it go down to Waco? Does it go up to Oklahoma? Those sorts of things is where it's a little more difficult to prove in case there is litigation in the future or someone else is using the same mark as you. So with Texas, this puts everyone in Texas on notice that you claim ownership of the mark. And that's kind of, once you go through the application process, you have a certificate of registration is rebuttable proof. That's what you get after you're cleared to have the registration and it's registered in the state of Texas. You are the owner of the mark and you have the exclusive right to use the mark in Texas in connection with relevant goods or service. Then if you move up to federal registration, that's exclusive rights to use in the whole entire United States. That's the presumption. Of course, it could be rebuttable, things like that, especially for the first 5 years. Once you get after the 5 years, it's kind of, it's hard for someone else to prove, like, I've been using this, they're infringing on me or I'm infringing on you, but you're the owner of the mark. And it puts, like I said, the public on notice. You're able to then record the U.S. registration with the U.S. Customs and Border Protection to prevent importation of infringing foreign goods. So that's kind of important, especially for the people who are not in the service industry, but in the products industry. And I can talk more about that at the end of the presentation, going over what's the importance of, the U.S. Customs and Border Protection. But they do inspect the goods coming into the U.S. And Texas is, a big port, has a big port on that. And they're also another thing that really distinguishes federal registration from no registration at all or registration in Texas is you're able to bring an action concerning the mark in federal court. So if you're saying like, oh, someone's using my mark in Oklahoma, I can bring in federal court. And there are certain perks of being in federal court versus Texas court, or a state court. And you're able to utilize the federal registration as a basis to obtain registration in foreign countries. So if you're hoping to expand into different countries, things like that, the federal registration of the mark will help you gain more connections and use people at the U.S. embassies to kind of help get you into those marks. And you're able to utilize the little R symbol. So as you're looking at products and things like that, you'll see some of them do have it, some of them don't have it. So that's kind of an overview of the different paths you can take on register of protecting your trademark from not at all to state to federal. So the cost of the federal registration may be more than the state registration, but the scope of protection is bigger, especially if you're hoping that this business does well and gets into other markets rather than that state. It also may help you avoid litigation, or if you have to go to litigation, it helps streamline the process, and you're doing that one thing before litigation ever happened. That shows that you're the owner of the mark because you have the paperwork and the documentation saying, I started using this on this date, instead of having to go back in your records and trying to find that first transaction to mark that first date. But that's another thing that we have to weigh the pros and costs, because all about starting your own business is about avoiding risk and shifting risk. Not all marks and names a company uses will be registerable. Example, if the program is internal, you have to use the trademark in commerce to be able to get registration. So if you're only using it internally, you're not selling it, things like that, it might not, you can't register it. And that's okay, because it probably, is not something to the extent that you need to protect your brand name, since nobody on the outside is seeing that. And it makes sense. Now, there is a possibility you can use another one of the intellectual property rights to protect that internal company program or something like that to kind of, protect you on that end. But this is specifically about trademarks having to use it in commerce. Further, if you're only going to use a mark for a year or two, it may not be worth filing for federal protection because it is a long process. It is a little bit of a longer process to obtain federal registration. So that's kind of something you have to weigh, whether or not you're seeing this business to only be in business, you only want to do this for a couple of years and then move on. You might want to balance the cost with the reward. However, if there is a chance that you want to use this for a longer period than just a couple of years, like, oh, I'm not sure, then definitely look at this and see about the federal registration process. It's a few $100s for the application, and depending if you use an attorney, they might need to be doing some research beforehand to make sure that, your mark is something that can pass registration and actually be registered on the Federal Register, which we'll get to another thing. So that's kind of all of those things. However, if you choose not to register a trademark, you still need to do some of these steps with trademark to make sure you're not infringing on someone else's trademark. So that's also another risk that you're taking with not doing the research with the federal registration or the state registration to ensure that you're not infringing on someone else's and opening yourself to liability and possibly having to defend yourself in litigation. So with when trying to come up with a trademark and trying to get it registered, I'm kind of going towards the federal registration process specifically, just because if you are going to register, it's more likely that you will just do the federal registration process. And when you are going to choose a mark and register it, you want to make sure, if possible, to present your best shot on the first try. And why does that matter? Because filing fees are non-refundable. That's the whole thing. So if you get through this whole entire process and it gets rejected and you still want a trademark, you're going to have to start the process over again. So the two things that the examining attorney, when they're looking at your application for the mark, is the likelihood of confusion with another trademark and the strength of the mark. I'll get to the strength of the mark in a certain, but those are the two things that we need to look at when we're coming up with our trademark and trying to get in the minds of the examining attorneys at the USPTO. So this is where you would conduct what is called a clearance search, trying to make sure that you clear all of the things, so you make sure that you don't have those awkward things of you go on social media, Google, kind of search the name or the word or the combination of the words and the symbols to on the federal registrar, make sure that they might not have registered their trademark, but you still need to do social media and Google just to make sure. Then go to your state where you want to register the mark. If you're only wanting to do state, kind of pop around there, do some research. That's also, I believe, on the Texas Secretary of State website, just in another section. And then go to the federal registrar. They have US TPO offers a free search system known as the Trademark Electronic System, known as TESS. The TESS help page offers some example and some sample search strategies on how to search their database of registered and prior pending applications to help determine whether any marks could prevent a registration of your mark. Now, this is important. When I mention any currently registered marks or any pending marks, because once you get into the application process, it's the date of filing that determines your priority in line. So if someone submits their application and it goes through 2 days before yours, then they're going to have to look at that and make sure that that mark, while still in the application process, isn't similar to your mark to where it would cause a likelihood of confusion. So that's also a something to consider on your timeline of making your mark, doing your research, and having this. And this research can also be conducted by an attorney, which I would recommend spending the extra money with the attorney, an experienced attorney on trademarks, to kind of look around the database. They know kind of what the elements are, what has gotten passed, what hasn't, those sorts of things. They kind of know kind of what they're looking for in terms of that because they have done this before. So they would probably go to the test, make sure to research, like I said, the Secretary of State's website, all of those things. Now, if you're wanting to do something in a foreign language, those words will be translated to English words for comparison analysis. So that's something to consider if you're looking to do that, and you need to search the English version. Phonetic sounds, if it sounds the same as well, is something that they will consider. And looking at this on a practical standpoint, it is more of an art than a science when submitting the application. So the trademark attorney, and a practice tip for practitioners out there, if you've looked through everything, you haven't seen anything like it, don't guarantee that the mark will get through and be registered on the first try without any issues, or that will be because the USTPO has done a lot of training. They have a lot of policies and procedures in place to try to make sure that their examining attorneys are passing things through or rejecting them in a consistent manner. However, you have to remember these attorneys are human. And so they have different experiences, they have different things that they have seen versus the other one. And that is kind of something that we need to consider whenever making it. So there's never going to be a guarantee. I know that there have been things that have been filed. You think that it's like, yeah, this will obviously get through. This shouldn't have any problem. And then there's, so many problems with it. And this other one trademark where you're looking at, it has nothing to do with it. So those sorts of things, or things that might be a long shot, might make it through. Now, I would try to operate on the more conservative withholding hope that it will get through, and try to do everything in your power to make sure that, it does go through. So that's kind of a couple of things to consider when when you're starting to come through. And when consulting an attorney, since this business, especially with small business owners, y'all are trying to create something that you're putting your heart and soul, tears, blood, sweat, everything into. And the attorney realizes that, and they want to make sure that, you have the best chance of doing so. So there might be a lot of, well, like, I'm not sure because this mark here that I researched, it's kind of similar, it falls into the same class, those sorts of things. And that is a difficult conversation, especially if you work so hard in creating this trademark and this logo that's amazing. And that's something that you have to kind of balance. So for best practices, I wouldn't necessarily be married to the trademark that you want to apply for. Maybe possibly having different variations, different words, things like that. Maybe having 5 when coming to your attorney would be a perfect world scenario. Of course, that, is more of a unicorn, but kind of going to the attorney like, I'm looking at these 5 different things, because I understand that trademarks, you never really know if it's going to get registered or not, if there's going to be an issue. Would you mind researching these 5 marks and telling me, which one should we go with? I really like this one right here. The first one, if you can kind of search that and see if there's anything, I would really like to go with that one. Might be a good approach to do so, that you're not having to start from scratch and your hope is, shattered, things like that. So that's kind of a practice tip that might help. It might take a little bit longer to come up with different ones, but it might be worth it in the end, just to make sure you have something to fall back on in case your first choice doesn't work out. So as I said, likelihood of confusion and the strength of the mark is 2 things that the examining attorney really looks at. Those are the most obvious ones. So I kind of have created a flow chart or a spectrum of where your mark can fall. So looking at the strength of the mark, you go from arbitrary and fanciful marks, which are more likely to be registered, and then all the way down to generic, which is you're not able to register it. So a fanciful mark, what is that? This examples of that is like Kodak, Exxon, Polaroid. So these are made up words which were invented to be used specifically as the trademark name. So that's a very high strength, and it's more likely that nothing else in the pending application or has been registered has come up with it, because it's not a common word. It's not anything. So that's one thing to consider. Arbitrary marks. This is Apple, Dove, Shell. These are words that have a real common meaning, but they're completely unrelated to the product or the service. So like Apple computers, like you get it. Suggestive marks are kind of in the middle. This is Jaguar, Microsoft, Netflix, named after a characteristic of the product or the service. So those can kind of go either way on that. Just kind of, you have to determine, you use the strength of the mark analysis and the likelihood of confusion together. So that's kind of where, certain things could go. Now, generic marks, Band-Aid, aspirin, thermos, they cannot be protected because they're simply a generic description of the product or the service. However, it is a fun fact, I'm a little nerdy on this, that some of these words used to be a trademark, but they have been diluted, which we can talk about later in the process, but they basically have, because other competitors started using it, and after a while, you associate any adhesive to protect a scratch or a wound or anything as a Band-Aid. And so it lost its strength and it's lost its trademark. So it's categorizing a whole area like Kleenex, those sorts of things. Specifically something certain surnames, because I think this has come up in the past. They cannot be protected without proof that has acquired a distinctiveness. If the public, and that what that means is if the public believes that it's primarily a surname and not a trademark, then it probably won't become a trademark. It has to acquire like, okay, I associate that with this type of brand of business. So that's kind of where we are. Remember, it's always the strength of a mark is always on the spectrum, and that's kind of where your mark will fall within that. So going through the application process, federal. On the right-hand side is the class of goods. So not only are we looking at the strength of the mark, the likelihood of the confusion, but they're also looking at what types of goods or services are you selling? Because if there are two things that are totally unrelated, but they kind of sound familiar, then it might pass because you're not applying for something, selling chemicals, but you want to also have an advertising and certain business type of service. That's where you kind of, that's where the subjectiveness and I think a little bit of the, individuality of the examining attorney kind of comes out, where they have to make these calls. So these are all the classes or with the goods and services that whenever, you apply, you kind of choose one, or you will fall into one of these categories. And that's, you have to file a trademark application online using the trademark electronic application system. And there are two different ways that you can. There's the TEAS Plus, which is $225, versus the TEAS Standard, which is $275. There's a little bit of a difference between how they, the price, obviously, but also how your application goes through the process. So the Plus has a lower filing fee per class. So the per, chemicals, paints, however many classes you're registering for that trademark. But in exchange for the discount, you have to meet certain requirements upfront and through this application process. One of the most important ones is the limitation in describing goods and services. So you have to select from this pre-approved list as to what you're selling or what you're producing. And the standard, it's more expensive. I believe it's $50 more, but you don't have to worry about the penalty that comes with the Plus. Because with meeting the requirements of the certain classes or things like that, you can kind of describe it and then it kind of goes through that way. If there's an issue with your application with the Plus or you don't meet your requirement, there's a penalty fee that comes with it, which is $125, which is greater than if you were to just go with the standard, which doesn't have quite as many limitations and more of a likelihood to get rejected. So it might be better to do the standard versus the Plus in that. So you also are thinking about who's going to be the trademark owner. Is it going to be you personally or is it going to be your business? Generally, we would advise clients to use the liability shield of a corporation form, whether that's an LLC partner, of a corporation structure through versus a person even though a person can own a trademark. It's just whenever, you're going through litigation or something, are you being sued personally, or is the business that's using the mark being sued? So you might want to make sure that, you have your business name set up, in that structure in place first. That's also kind of leading into whether a parent company and a affiliated sub company, a parent company can benefit from trademark rights from a sub entity, but it's not quite as automatic from the sub to the parent. So just something in mind as your small business expands or grows or adds in, and becomes a parent entity, those sorts of things. So within the application process, you will have to send in what is called a specimen. And in plain English, it's the picture of a photo packaging, screenshot of a website. It has to be customer facing. So it can't be a mock-up or proof of the actual materials given to the customer. It has to be something to be given to the customer. Advertising's not, this is where the difference between a service mark and a trademark. Advertising is not acceptable for goods application, but it is acceptable for a service application. So a service, really quickly, sorry, got a little ahead. Signatures, whenever you sign the application, this is a statement to a government agency, so just be aware of that. The person signing it needs to have authority to bind the company. And you are also required to monitor the application process through the trademark status and document retrieval, which is the TSDR. I know there's a lot of acronyms in this. So you must check the system, best practices to check the system at least every 6 months. You should really check more so you don't miss a deadline, because they're usually 6 months. And make sure you maintain your address and email in the application. And as I said, the filing date of your application determines your priority. So this is just an example of the office action and the potential response that you can have. So an office action, if the examining attorney finds issue with your application, then they will need to send out what is called an office action. This will lay out the substantial issues or reasons for refusal of your registration mark. You think that's it? Not quite. You can respond. So definitely read the form thoroughly. It's going to be weighed down with the legal jargon, statutes, these things. But so the issues with your actual trademark might not be as obvious. And this is where an attorney is really helpful to kind of understand and parse through that. So make sure to research the facts and the law. So like similar marks that, they're saying is similar or things, and then you can respond. So that's kind of on the right side, that's kind of a meat of the response. Unlike this mark is very different, all those sorts of things. If you do it yourself, there will be a form that you need to answer. You can then upload your argument and then make sure to put effective evidence to show that how it's different, those sorts of things. Sorry. So make sure when you're monitoring it, a government examining attorney will send an email to you, and it will come from ecom@ustpo.gov or some variation. So just be looking at that and know that there's a 6-month deadline to respond to the office actions. And this is where you kind of have to determine whether or not, is this an operational issue where the graphic just isn't as clean, so we need to submit another graphic, or is this a legal issue where they need different arguments and things like that? This is where an attorney could be really helpful. So how do you protect your rights once you've got them? So if the mark isn't protected, it could become legally weak in the strength of the mark, remember, and even generic, like Band-Aid, which causes the loss of the exclusive right to use it and its investment, that's the exact reason why you wanted to protect the mark. So once you have it registered, you need to make sure that you're monitoring it. Now, how do we monitor it? You can monitor it through Google Alerts with the name or the specific combination of words or letters. There are also companies that can monitor it for you. Sometimes your attorney will, if they provide that service. That's something that you can work out for different things. So that's kind of where we have, in order for time's sake, because I can talk to a brick wall, I'm going to move on to copyrights. A copyright is another type of intellectual property. It does not protect facts or ideas or systems or methods of operation, but it may protect the way these things are expressed. So you might have like books or music, artistic, even dance choreography can be protected, which is pretty interesting how they do that. And it protects the normal things that you would think of, pictures, those sorts of things. Now, remember, it's different than a trademark because a trademark protects words, phrases, symbols, or designs, identifying the source of the goods. You're using the double arches to identify that's McDonald's versus the McDonald's commercial, which would be a copyright. So just to know that, you know, for works created after January 1st, 1978, copyright protection lasts for the life of the author, plus an additional 70 years. For anonymous work or work under a pseudonym or works made for hire, a copyright has a different term. It endures for a term of 95 years since its first publication, or a term of 120 years since the year of its creation. So publication is, you know, putting it out into the world. Creation is, you know, creating it. But it's whichever one expires first under that specific thing. You do not have to renew the registration if you've published the copyright works after January 1st, 1978, which will probably apply here if you're just starting your business. But prior to 1978, the reason why I wanted to mention that is just in case people are like, oh, well, you have to renew it. You know, it's optional to renew after every 28 years. That's for works made before. So why do we care? Well, your work is under copyright protection the moment it is created and fixed in a tangible form. So like actually painted or actually, you know, the picture's taken and printed. And it's even on the computer if you can be able to see it. So confused, you will have to register the copyright in order to commence a lawsuit for infringement. That's the difference. So while it's technically protected, you can't do anything with it until you register it. So you might also want to have the fact of registering your copyright on public record, and you have that certificate of registration to show that's like, no, I own this. This has been since, you know, 2020, when you're suing in 2025. So if the registration is made within 5 years of the creation, then it's prima facie evidence in a court of law that you are the owner, that, you know, that you made it. And that is a good start to the litigation if you need to. It's not like completely set in stone. Once you say that, then they completely rule on it, saying that you're the winner. But it's a big hurdle that you've already jumped through, is the point. So trade secrets. This is something I just wanted kind of to touch on. People always throw around what a trade secret is. And with these slides, of course, as Callie stated, that they're going to be sent around. But this is something to think of when you're considering something is valuable to your company that you want protected and that you could possibly have to go to litigation for. Because you need to make sure that these are the elements the court is going to look at. And these are something that you need to keep in mind to maybe put safeguards in place. You know, make sure you don't tell other people or things like that. And maybe keep a centralized secret. It's like the Coca-Cola recipe. There was a huge lawsuit with it, and whether or not they had to go through these factors to make sure that it was a trade secret. Like, who within the company knows it? If there's only a select group of people, that is in favor. And whether you've taken reasonable measures to protect that information, like through cybersecurity, things like that are important to continue. Same thing with patents. You know, it's a type of property right. That's your invention of the lawnmower that runs on oranges. It protects it for, you know, a limited time to exclude others from making, using, or offering to sell or selling or importing. And there are 3 different types. A utility patent is that long document paper, the process. And a provisional patent allows investors to file a less formal document that proves the inventor is in the possession of the invention and has, and it gives them time to adequately figure out how to make the invention work. That's where you hear on these infomercials, patent pending. However, if they fail to file a formal utility patent within a year from filing the provisional patent, they will lose their filing date, which same as trademark, it's important. And then design patents, like the ornamental design of a useful item, such as the shape of a bottle, like Coca-Cola, or a shoe. And they also have plant patents, which is like the creation of new kinds of plants. So general business tips. Again, as Candace said, business records are very important that you maintain them in a good way. I was going through document production for litigation, and we had these huge boxes just filled. I mean, they weren't even like facing the same way they were thinking. And then I found, you know, receipts, one of them, which was pretty awkward, a receipt for a pregnancy test and the Snickers. So make sure whenever you're having those sorts of documentation that it's business, and then keeping your personal record separate. It's just like, you know, you don't commingle funds. You don't really necessarily want to commingle your papers and your business records and things like that, because it also saves you money if you have to go to litigation. Like how Candace was saying about the records, the text messages, and contracts and communications. If you have a system of organization, you can spend less time having it organized to your attorney, because they're going to be what is called discoverable. So you have to share them to the other side, but your attorney has to go through them and kind of make sense of them and organize them. If you give a nice organized set of records to the attorney, then your attorney is spending less time, therefore less fees trying to go through them and make sense of it. Same thing with policies and procedures. The next person will definitely go through those, but just make sure if you're having, you know what your policies are. You know, sometimes they get a little outdated, but try to make sure they're current and that you're actually acting on those policies and procedures. Now, with the FTC, there is a growing market for influencers, social media influencers, and who doesn't want to jump on that wagon, especially if you can get it out to the world on a large scale audience. As an influencer, if you're trying to make that your personal business, it's your responsibility to make these disclosures that are required by the Federal Trade Commission, to be familiar with the endorsement guides, and to comply with the laws against deceptive ads. Don't just rely on the platform that you're on, like Instagram or Snapchat, you know, to make the disclosures for you. You really have to be the one to make sure. And there's an obvious requirement. The FTC recently posted, gave guidance onto what they're looking for and what will be in violation when you're trying to market a product or a service. It's the obvious requirement. You have to make it obvious when you have a material relationship with a brand. Now, what is a material relationship? A material connection to the brand includes a personal, family, or employment relationship, or any type of financial relationship. So if the brand is paying you, but also if they're giving you free or discounted products or services, then you have to still disclose when you're making that review or that, you know, that plug for it. It doesn't matter if you think the evaluations or reviews are unbiased, and don't assume that your followers already know about your brand relationships. So you can't talk about your experience with a product you haven't tried. That's kind of obvious. Sometimes it goes around like, oh, I'm sure she hasn't tried this. They actually have to, and it has to be honest. So if you think it's horrible, it can't be terrific. You can't say it's terrific, and you can't make up claims, because that will get you in trouble saying that it'll cure cancer and it doesn't really. So make sure that you understand what the product is actually going to do. Further, liking something, so tagging, likes, pins, and similar ways of showing that you like a brand or product is an endorsement. It's not just about posting a video about it, but just simply liking it. If you have a relationship or something like that, that's an endorsement. And if you're posting from abroad, US law applies if it's reasonably foreseeable that the post will affect US consumers, like if they will see it. So foreign laws might also apply as well. If but if you have no brand relationship whatsoever and you're just telling people about a product you bought and happen to like, you don't need to declare that you don't have a brand relationship. That's completely fine. So where do you place this, statement that I am a brand, it's a sponsored post or something? You have to make sure that's hard to miss. The good rule of thumb is if you have to click something to be able to see the endorsement, then it's not a good placement. So if you have to click more, or if it's in your bio or profile, probably not a great place. So you need to kind of make sure. So like in the video, you should probably say it in the video and not just the description. If it's a live stream, periodically repeat it. So if only viewers receive a part of it. Again, these are best practices. Snapchat, if your endorsement is on a platform like Snapchat, superimpose the disclosure over the picture and make sure viewers have enough time to notice it and read it. So when I'm saying, make sure that you make a disclosure, say like, thanks to Acme brand for the free product or advertisement, ad, sponsor. You can also combine the letters saying, Twitter, like I'm Acme partner. Don't use vague or confusing terms like SP for sponsored, and it must be in the language that the endorsement itself.